All right. Hey guys, thanks for joining me here for this seminar tonight. Um, this is one that I'm actually excited about for uh, quite a few reasons, and hopefully those reasons will come through as we start talking about flipping the tables from law to equity and how to keep inequity. And that is what this seminar is about tonight. Hope you guys can see my screen. I hope you still can see my screen and that you can hear me all right. Uh, Somebody maybe give me an okay.
All good.
Perfect. All right, thank you. All right, so this the seminar is how to bring or to stay in equity, how to bring equity because you can't find equity where you go into the court. Lots of folks have tried to go in and find it there or get it there, right? But it's something that you have to bring with you, okay? And there's a lot more to it than what most folks that are sharing about this online are telling you. It is not. It is not statutes and codes and case law and all these other things. That's the law side. That's law. And when law fails, equity steps in. It'll step in for a second, and it could step in and be kept there if done right. Equity seeks preservation, okay, before destruction, before things go bad. All right. It is an educational seminar, okay. We talk about administration and stewardship. Okay, that's because that is a part of equity. It's living it. It's how you operate day to day. All right, it's not legal advice. I don't represent anybody on the call, and this is not a promise of litigation outcome. But what it is over the years I see people going and fighting and arguing and wanting to get revenge for lack of a better word. But I guess that pretty much says it. They did me wrong and they owe me, and I'll argue until I'm blue in the face, or until at least they'll stop accepting my presentments to the court or to the other party. Anyway, that's kind of why I wanted to put this together. There's a lot of folks that come to me that yes, they want to learn about trust. Yes, they want to see how to move and be able to live their lives in private and protect their estates, the things that are entrusted to them, right? But a lot of folks come and are looking for solutions to very real legal problems. I say real in as much as fictions can be real, because in the law side, you're dealing mostly in fictions, statutes, codes, constitutions, and the opinions of judges or men or women. Um, anyway, so let me turn that down so we're not getting that. Turn off my ringer here. So again, I wanted to be able to provide real remedy that can be utilized um, every day. It doesn't even need to be used in a court unless it has to be, unless unless there's that is something that's before you. But it is something that's simple and can be used now. You don't need to study all the law books and find the right statute and code. Um, Equity is much simpler than that, and there's a much shorter learning curve there. Okay, there's a much shorter learning curve. It's much easier to learn a few maxims and how they work within that system than it is to go into the law library and come out 40 years later and still not figured out what it is that's going to get you the remedy that you're looking for. So, on that note, this is not legal advice. I don't represent anyone except for my estate from time to time, and depending on the capacity I need to act in. I'm trying to hide these. So anyway, sorry. All right. Basically, everybody's responsible for their own research. I've been saying it for years. All right. So let's get to some. Let's get to the milk part of this, and then we'll move into some deeper concepts. All right. So why does equity exist in the first place? Okay. Little history. The law itself, was oppressive. The common law. Okay. Was oppressive. They had very specific situations, and if yours didn't fit into that situation exactly, a lot of times parties, these judgments and things were very lopsided and very technical outcomes, harsh enforcement, procedural rigidity, just like what you see when you go into a statutory court and you're dealing with the law side of the court. Okay, it's very technical. Right? It's you feel like you got run over. There's harsh enforcement. There's procedural rigidity, timelines and deadlines and calendar dates that you need to remember, and all these different things that have to do with the rules of the game. Okay, procedural rules. All right. So equity emerged to preserve fairness, protect beneficiaries. Again, trust. This is where trust was born in equity, and as we go on, you'll start to see how one of equity's main goals was to protect beneficiaries, okay, and to prevent irreparable harm, damages, okay, that can't be fixed. So when you compare law versus equity, and if you didn't see, I also posted in the group a law versus equity document that gives a bit much, more of an understanding of this disparity between law and equity. Okay, the law is very strict: enforcement, procedure, and damages, and they push cases through, like they do at the grocery store teller. Okay, equity, it talks about preservation. Equity is about preserving rights, right? Preserving property, preserving a situation as the status quo, right? It's conscience based. Okay, it's the spirit of the law, where the law side, the statutory side, is the letter of the law. Okay, it's law without conscience. Law has no conscience, is what I'm trying to say. Okay. And rather than damages, equity looks for restoration, to make things, everybody involved. Equity would be fairness. Everybody involved back to the prior state as if nobody, interacted. So that's where we get down to the heart of it. Equity is a restoration. Okay. So what are the four pillars of equity? Equity, you have stewardship, right? That accounting, preservation of rights, preservation of property, and a fiduciary integrity. Okay, which goes hand in hand with stewardship, which goes hand in hand with accounting, which goes hand in hand with preservation. These are all duties, okay, of a trustee. Now, I want to put this out there, okay? I'm going to show you how equity works within, trust for specifically, okay? But what I'm showing you, look deeper, look at the opposite, okay? Look at this as the public side, the public trust, okay? Are they being good stewards? Would they provide you an accounting? Are they interested in preserving your rights, or the rights that you have an interest in, or your estate has an interest in it? And are those trustees in the public? Are they, do they keep to their fiduciary duties? Do they do what they're supposed to do? Okay. This is what equity looks at. And all four of those things are the duty of a trustee. And again, you're gonna hear me over and over talk about this from a trust standpoint, because if you're going to live in the private, that's what you do. But equity will help you either way, whether you are, protected in a trust into the private, or if you're just, trying to get the right thing done because it was the right thing to do. Okay. So why do trusts belong to equity? Okay. Trusts require fiduciary duties. Trustee is supposed to protect the beneficiaries. That's their duty, right? To protect and defend the beneficial interests and to account for everything that they do within their administration of the trust during the time that they are trustees. And again, keep in mind that the public trust is supposed to be this way as well. Okay. So what's a trustee's role? To be a steward, a fiduciary, and a preserver of someone else's property other than their own. Okay. So this is how equity is tied to trust and how trusts were born in equity. So trust issues are dealt with and can literally be brought in an equitable claim to, protect, either bring or defend it in in equity. And it can stay there if you just understand how it works. Okay. All right. So beneficial interests. Equity asks who benefits? Who benefits? And who bears the burden, right? You've all heard that he who brings the claim bears the burden to prove it, right? So again, if you're bringing a claim, you have the burden of proving your claim. You also, in equity, have to come with clean hands, right? There's a few other things that are required to bring equity, right? In order for it to be, to literally pass a test that it is equitable, right? That what you're bringing is truly equity. So who benefits? Who bears the burden? That's what equity asks. Who is the beneficiary and who bears the fiduciary burden? We'll say it one more time. Who's the beneficiary and who's the trustee? That's what equity asks. Okay. Accounting. If you don't have an accounting, okay, everything is weakened. Okay. Equity's weakened, right? I say it is this. The books look like, yeah, I don't have the books, but I do have some receipts. And, your argument, your evidence is weakened. Facts don't require argument. They're facts. Okay. But without an accounting, preservation collapses. You can't prove payments or anything else. Okay. Oh, and let me throw another caveat out there. Equity has everything to do with you, not the other side. How you deal with it. Okay. Doesn't matter what they're doing, whether they're doing it right or they're doing it wrong. You're not there to point the finger at what they're doing wrong. Anyway, you're just bringing the facts. The truth overcomes fictions every time. And again, in the statutory side of the court, the law side of the court, that is presumptions and assumptions and statutes and codes and other opinions. Okay. Very hard for them most of the time, even though they have these accountings, for them to bring them forward. Okay. I don't want to get off track, so I'm going to move on. So without an accounting, equity gets weakened, preservation falls apart. You can't prove that the property is yours, and transparency disappears. Okay. There's no transparency, right? So these are things that happen when an accounting is missing. All right. Without it, you can't prove that you paid for the property, so you have no rights of subrogation or the claims. Okay. Beneficiaries lose their protection. That's a breach of your trust. Okay. And again, look at this stuff, both sides. I'm showing you uh, from a private trust side. That's the focus I'm doing here within the presentation. But look at how this should be how it is on the private when you're administrating your affairs in equity. Okay. But anytime you see a trust operating that isn't doing these things, there is a way to hold those trustees, those uh, stewards accountable. Okay. Judges cringe when equity enters the court because everybody can be held accountable. Anyway, moving forward. All right. Oh, sorry, guys. I gotta move down here. Okay. So, what does an accounting include? Balances, transfers, fees, property records, beneficiary allocations, preservation expenditures. Okay. It isn't just the numbers, but the administrative records that go along with it that explain those numbers. Okay. Property records. So you'd have a chain of custody, right? Chain of ownership. But before any enforcement, okay, they have to show the accounting. Why don't they? Because most people have no idea. Okay, especially folks trying to, act pro se and go in and battle, banks for foreclosures or dealing with, situations in a probate, maybe family disputes, things like that. Okay, but an accounting in equity is huge. Okay, because you can't account for something that you don't know. Okay, if you don't know what the accounting includes the subject matter of the case, then how could there be a case in the first place? If that makes any sense. Anyway, moving on. So under law, okay, this is what it would look like, and we'll look at just at foreclosure as an example. Okay, the law frames foreclosure as default, right? There was payments missed, okay, enforcement, and sale. That's it. They're looking at, yeah, was there a default? Yes or no. Then there should be enforcement if yes, and a sale. Okay. That quick, that easy, very simple case to make, right? But it doesn't take into consideration all the variables. Okay. Equity says, is the accounting complete? Are is all the paperwork there? Is all the administrative communications there? Is the accounting complete? And more importantly, are beneficial interests endangered? Was there equity in the home that they're foreclosing on? If there's $500,000 in equity and a $200,000 debt, then who's got the higher claim? And would this action somehow take away from the ones that have a true beneficial or equitable interest in the property? And if so, the court needs to protect their interests from unjust enrichment. Okay, so irreparable harm. The courts, okay, when you look at irreparable harm, again, I didn't mean to cover declaratory actions and things like that, but it's a good example. Writing in, putting in a declaratory judgment action to protect the estate from irreparable harm. Okay, the court would have to recognize that by doing something or not doing something, or not ordering someone to do something or not do something, could irreparably harm the estate. Okay, then equity recognizes, the equity part of the court has to take interest in that from an equitable standpoint, and it's how you plead that will affect whether or not that will happen. Okay. And as we go on, you'll see that. So injunctions are an equitable relief. Okay. A lot of times in a declaratory action or any equitable action, you're going to seek injunctions, right? Stop irreversible harm, preserve property to maintain the status quo. An injunction is to get somebody to do something that they're supposed to do or to stop doing something they're not supposed to do. Okay. Until all the evidence is seen. So injunctions are a tool of equity in the court system. All right. Equitable redemption. Equity preserves rather than forfeits. Okay. So there's equitable redemption, opportunities to cure. These are remedies that equity can provide and interject and pull out from the legal side of the court. It's bringing conscience to the law. Okay. Again, if you were coming here to expecting a magic pill or some magic document that works, the rules of equity are very simple, guys. Very misunderstood because they very rarely get utilized. Again, people go there trying to find equity in the court. The court's not going to provide it. You have to bring it. That'll become more obvious as we go on. Okay. So equitable redemption, constructive trusts. Okay. When you go into a courtroom, most of the time, you're going in to say, pay a ticket. Okay. You don't know it most of the time. Most folks don't understand how this works. But when you go in and they open a case, right, they're creating a constructive trust. When they call the name and you answer, you just became the surety, the trustee over that name, okay? And in the court, okay, and the state, the state becomes a beneficiary, okay? And the court gets to be the administrator, okay? Also a trustee, but they get to administrate. You get to pay, and the state gets the benefit. So there's a hidden benefit, there's some fiduciary abuse, and there's some unjust enrichment. These things, okay, are literally trigger a constructive trust. So I'm showing you how to utilize a constructive trust as a remedy, right? That's what that's how we use that equitable principle of constructive trusts, okay? We can construct a trust as well by expressing the parties and the duties that are owed by those parties, if any. Okay. But on the public side, constructive trusts are created in every case coming in the door. I'm not going to go into that deep, but you can do the research, just like I said up front. All right. Unjust enrichment. This is one of the things, again, that equity abhors, okay? Okay, nobody is supposed to benefit at the expense of another, okay? That's unjust enrichment. So equity, if that's happening, equity can step in to protect someone from having them taken advantage of by someone else. Okay, unjust enrichment. Preservation first. Okay, when you're a trustee, preserving the trust estate is your job, just like in the public, where they take a oath, right, as they become public servants, public trustees, to preserve and protect and defend their constitution. Their indenture is what that is. Okay, so they really think they're doing their job. Okay, whether they are or not is not for this call. But the equity mindset is to preserve the estate's assets, stabilize any potential threats, right? And before any judgment, there has to be an accounting. There has to be an accounting. It's part of the facts. It's the main facts. It's all the facts. Okay, then it was Was there anyone who was in breach or didn't fulfill a duty? So the law looks at procedural warfare, and that's what you're going to have. And you'll start a case, and that case can sit in a court for years. Okay, deadlines, ping pong back and forth with pleadings, right? Hard to get an accounting if there is an accounting, and literally emotional chaos across the board. Most folks go in and they want equity, but they, end up getting trampled over because they don't understand the procedures or how to bring equity, right? They go expecting it to be there when they get there. And good luck with that. So, collapse signs of procedural warfare, okay? And when you go into the law side, it's all about rules of procedure, rules of evidence, okay? If you don't know the rules of the game, you miss deadlines, you can't account. In other words, you can't provide the evidence to make your case. And then you get frustrated and escalate and argue. The second you start arguing, you move yourself back into law. You move yourself right back into law. So if you had really gotten into equity, just arguing is going to put you back into that jurisdiction. And it is a switching of the jurisdiction, the authority, and the things that have to be done. Okay? All right. So where we, from an equity standpoint, rather than procedural warfare, although those things are very important, very, very important to be aware of schedules and time frames and things and what's going on within a case, okay? And the best way to do that is literally record warfare. I call it record warfare, but strong systems, okay? Have your accounting, no matter how many binders it takes, okay? You have evidence. You can prove everything along a timeline, and your evidence fits your timeline. You preserve your rights, and you're providing, you're notifying the other side that you're preserving rights all the way along. You do not waive, right? Or sleep on latches. These are all maxims of equity that I'm giving an overview of the principles or the concepts of equity, okay, and how to use them practically, okay? Whoever controls the record literally wins most of the time, okay? You can only account for what you can, what you're entrusted with, and that's your job. Who's doing that in the public? You can call an office and every day for the week and never speak to the same person twice. So you have to keep the record. I've seen records disappear out of cases all the time. Work with a lot of folks that's happened to over the years. So record warfare, okay? You are a record keeper. Otherwise, how can you account? Okay? But even if you did half of what I'm telling you, you'd be doing better than the public side will ever do in preparing and being able to present a complete record, a complete accounting. And that goes for most corporations, banks, things like that. They'd have a very hard time producing the full accounting. But in equity, it is required. Otherwise, you can have the numbers, but what do they mean? What was agreed to? What's changed? How many times have you got a notice from a bank that says, we're changing our things? Well, you don't have to respond. We're going to do it anyway. Things change all the time. So the record has to change. And if you're not aware of what changed when, they notified you. So a lot of this falls back on you to keep strong evidentiary records and accounting. Okay? accounting binders, timeline logs, preservation notices, right? What did you do to preserve the status quo, or to reconcile, or what's the word I'm looking for? uh, to be able to bring everybody back to their original status, okay? And records of communications, okay? These are all evidences that make the equitable claim stand, okay? They make it stronger, harder to dismiss, right? If I bring and let me just give you an example. If I bring a solution to the court that makes everybody happy, everybody may not have gotten what they wanted, but it settles the issue right now, right today. And something that can't be argued. Everybody's either, winning, losing a little, but it's settled fairly. All parties go away, maybe not thrilled, but, settled. They have a hard time dealing with that. They have a hard time dealing with that because lawyers want to argue. The courts want you to argue because then you're there and they're getting paid and the lawyers are getting paid. So you can argue, and they'll argue as long as you have cash to pay for pleadings and for appeals and all these other things. All right. So, and again, we went through this. I'm adding here a remedy tracking. Okay, when you understand equity and the signs, the warning signs, depending on the whatever the crisis or situation that you're dealing with, okay, equity has remedies, and literally you can point to, you can read through the short list of maxims and figure out very simply what applies. All right. Equity loves organized evidence, transparent records, and consistence, okay? Straight across the board. Now, I don't know about anyone else on this call, but I've talked to lots of prosecutors. Most of them have between 300 and 500 cases on a desk, okay? Not organized evidence. Most of them really don't have a whole lot of understanding about any of those 500 cases, okay? And they get, little triggers that will, oh yeah, I remember. Oh yeah, that's what this is about, okay? But it can't be consistent. It's too much. It's overwhelming, okay? So organized evidence. If you've got it, you're doing way better than the other side that's going in law, that wants to do statutes. Yep, this was violated. This code was violated. This statute was violated, which means there has to be enforcement and payment. Okay? Equity doesn't look at it that way. So every communication, every interaction between an opposing party, okay, or any third party that is putting in their 2 cents in a case, okay, any interaction, keep it calm, peaceful, organize what was said, okay, transparency, preservation, focused, your communication. How do we save the asset? How do we stop the bleeding? How do we keep the lawyers from making, 50% of the estate, right? Because we can't agree. Where's the accounting? Who owes what and why? Okay, all communications. So, when you're dealing in law, arguing any arguments, guys, whether this happens in a courtroom in your own house, weak communication is emotional, aggressive, inconsistent, threat-based, and chaotic. It's not a strong place to communicate from, And most of the time, this will collapse equity right into law, because equity requires, some form of rationality. Okay. But if you're irrational and aggressive and inconsistent, you're right. One day it's this, the next day it's that. You start swinging threats, and everything is chaotic. There's no order to the process. Equity will come in and fix those things, but for communication, the reason why we communicate and document all of that, okay, because this is what we're looking for from the other side, okay, for them to get emotional or aggressive or not be consistent in what they're claiming, okay, not have the evidences that they say, oh, it's this, and then over here they say, no, it's that, okay, inconsistency, threats. Well, if you don't, do what I say, then you've got to be out of that house in 72 hours, right? That's not unless court said it, right? It's just threat-based communication that makes whoever's doing it weak and their position very weak. So how do we lose equity? Okay, we go at things emotionally instead of systematically. We're not ready, right? We focus on revenge, damages, what they owe me, what they've done to me. Okay, ignoring the accounting. If somebody has an accounting and you've received that accounting and you've ignored it, you owe payments, you just ignored it. You missed deadlines, and you're in breach of your fiduciary duties, right? You're not properly keeping records. You're abandoning the preservation of the property by laying it to waste. And I mean that in a way I'm just looking at this as foreclosure situation, or a situation where you are entrusted with a property and you stop paying on it, and foreclosure happens and equity disappears. You're the one that's in breach of trust by abandoning the preservation of the property in the first place. Okay. Inconsistent remedies will put you right back into law every time. They do not want to be in equity in the courts, not even a little bit. It's inconvenient. So if you go in there and you want, I want $100,000 for you stopping me on the side of the road, you're looking for something that isn't equitable. It's not fair. It's just some number you pulled out of your rear pocket. It's not going to help you, and it definitely would put you right back into that commercial law jurisdiction. You will not stay in equity that way. And they hope that you don't know enough to keep your language, right, your communications back and forth equitable, peaceful. All right. So common collapse patterns when equity collapses back into law is when emotions come in. You start focusing on commercial things. You're ignoring your own accounting, right? You don't file in time. You can't provide the evidence. Those are things that are going to collapse your equitable position right back into statutory enforcement. So how do you preserve equity throughout a litigation? Okay. Because if you're going to court, there's got to be a goal. Okay. That goal cannot be endless whining and crying and fighting and arguing over procedures. Oh, they didn't file this. They didn't file that. I didn't get my due process. There's 100 arguments you can come up with, and if not, they'll throw in and instigate with some more just to keep it fighting. Equity wants peace. In order to get peace, you've got to bring the treaty. Okay, so the goal in equity is not to stay in an argument, in a fight. All right. It's in litigation. Your goal is to either avoid it or end it. Okay. And the way that you do that and stay in equity, okay, is by forcing the accounting, making sure that you're preserving the asset in question or the issue, the interest in question, a claim, right? Or an ownership right, whether that be you as the property, okay, or something that's within your trust. If your job is to protect the beneficiaries of the estate that you are a trustee over, okay, then that's part of your job to preserve that protection and their interests while litigation is going on. That litigation isn't going to excuse you from your liability as trustee. You have to maintain fiduciary discipline, keep the bills getting paid, keep making sure that everything is as everything should be. Do your actions pass a conscience review? Are you doing things the right way because they're the right, doing things the right way because it's the right thing to do? Okay. So equity has to be maintained continuously. It's not just some thing, some tool you pull out of your back pocket, which is why if you understand these principles, these simple principles, that you should be able to defend your interests, whether you're in a trust or out of a trust, by walking these principles and utilizing them whenever there is conflict. Be the peacemaker, and that's what equity is all about: is being the peacemaker, bringing equity, bringing the solution, not going in and complaining. 98% of the people will go in and complain in a court, making no legitimate or solid arguments that can be, it's he said, she said. It's arguing back and forth. Tennis match that doesn't end until a solution is come up with. So bring the solution and it'll be over. All right. Probate. All right. And this is something that's very near to what to my heart, because for the last 2.5 years, I have been dealing with the probate of my mother's estate, who died intestate without a will, not for a lack of trying, but for fear of talking about death. Either way, I can tell you for sure, absolute fact, that probate is way more than just paperwork. Okay? It is stewardship. The personal representative of an estate is a fiduciary. It is a equitable situation if done properly. But it can easily go into law and stay there for a very long time if you're just following the rules of civil procedure. You're just following the rules. I followed all the rules. Why didn't I get my remedy? Yeah. Because there is none there. The law doesn't provide you a get out of jail free card, unless you know somebody. I don't know. All right, moving forward. So probate is about protecting the beneficiaries, the heirs to the estate, preserving property, and accounting, inventory of all the things that were left within the deceased estate or the decedent's estate. Okay, and then proper fiduciary administration, doing an accounting, selling off assets, liquidating the estate, and then distributing it out equitably to the beneficiaries and heirs. Okay? So, issues that can come up in probate: occupancy disputes, if there's real property and someone's in there, or has an unfair advantage, right? Or hiding assets and you can't find them, right? Or excluding other heirs and beneficiaries through adverse possession, right? A fiduciary not doing inventory, not accounting for the property within the estate. Okay, all of these things become issues of equity. Somebody is gaining while someone else is losing, right? Beneficiary exclusion. That's a huge thing that equity will step in to fix. Right. So equity, and this is again why judges don't like it, because these are the things. Prosecutors don't like it. Lawyers don't like equity. Most lawyers, I'll say. I'm not going to generalize them all. Someone might like it, but the reason why is because it looks to the conduct, transparency, consistency, preservation, stewardship, accounting. None of those things mean billable hours. None of them. A declaratory action, for example, goes to the top of the docket. It means that I don't care if you've got 100 motions on the table, that goes to the top of the docket, not just the case docket, but the court docket, because it involves the rights of the parties in a case, and it could literally stop unneeded litigation, saving the courts and the taxpayers and all this time and money and whatever. Okay? So equity examines conduct, transparency, consistency, accounting. Okay? And the trustee, you become part of the evidence. You become part of the evidence. Did you do what you were instructed to do by your indenture? And that goes the same and double for the public. So, offensive and defensive equity, okay? How to bring and how to defend, okay? And equity deals with both of those very specifically, okay? Offensive equity, bringing a claim, demanding an accounting, seeking an injunction, right? Preserve property. Hey, this is happening. We need to the court needs to step in and preserve property. The court needs to clarify rights. The court needs to figure out and stabilize the controversy between the parties and administrate so that the property can be preserved. Okay, so these are things that can be utilized offensively, and some of these can be used contrary on the excuse me, on the defensive side as well. Okay, so defensive equity, preserve beneficial interests, prevent forfeiture, prevent benefit or protect beneficiaries, okay, from loss, and resist unconscionable harm. So unconscionable harm. A lot of times you'll hear unconscionable when it comes to contracts, right? And those things can be avoided. So there's a lot of things that equity will uncover and focus on and bring that consciousness, substance, okay, to settle the argument, to get to literally to settle the argument. That's the goal, offensively and defensively, guys. So when we talk about advanced equity warfare and complex multi-front controversies, if you're managing all your affairs, if you're properly structured in a trust estate and you're managing your family office, it can and does happen, from time to time, depending on how you interact with the outside world, how many interfaces you're juggling. Okay, but things things come up: foreclosures, probate, conflicts with beneficiaries within the trust. A trustee or a keeper didn't do the right job, right? Or some other trustee overreached their authority. Okay. And then you've got to think about appellate preservation. If you're in a legal battle, if we lose, what's next? And you don't come up with that strategy after the fact. In equity, it's got to be your number one goal up front is to preserve that, the record, the evidence. Okay. In case there is some administrative overreach. Right? in the matter that's being handled in some case in some court. Okay. Equity can hold all parties accountable. Okay. Clean hands, guys. All right. So a mature trustee, somebody who knows, who is a good trustee. Okay. Accounting, preservation, and stewardship. Really simple. Keep the records, preserve the assets, and be a good steward and be able to prove it through the above two. What you've done, your deeds, speak for themselves, guys. You just have to record them. So, centralized systems. When you are managing a trust estate, if you are entrusted with things, we want to simplify that. If you've been entrusted with anything, okay, managing that thing is good to have an accounting, be able to have a good accounting system. Okay. How would you preserve? We'll take a vehicle, right? You have a vehicle. How would you preserve that vehicle over time? Right? You put it on a maintenance schedule, right? It's kind of the same thing. Who is the beneficiaries? You map out who is the one that's supposed to be benefiting? Are they in danger of losing the benefits in any way? Right? They're the beneficiary is who the remedy is tied to. Okay, so mapping the beneficiary in order to be able to coordinate a remedy. It's good to have these documentary systems, these record keeping systems. Timeline management. I can't even tell you how many calls I've done on case management, setting up a case folder, organizing a case folder, tab by tab by tab, so that you don't miss court dates, you don't miss, filing deadlines, so that you don't have to do twice the amount of work, to fix the mistake that you made in the first place. And constant appellate preservation of everything, not just the evidence, but how you acted equitably all throughout. You were constantly, bringing equity, being there with clean hands, and accounting for that, right? Expressing it, showing it. Your acts match your words. Organization is leverage, guys. Systems, prevent collapse. Systems prevent collapse. Think about that when you think about the public and how long that public system has been going and wherever you are. So systems that keep it from collapsing straight away. Because only, this office, this person in that office knows their specific job, and that's it. It's not, the whole system doesn't collapse because of one thing, and a trust doesn't collapse for a lack of a trustee. Okay? But systems do keep, things from collapsing into chaos. And I don't equate chaos to anarchy because those two are not the same thing, even though you may have been led to believe that. I'll just throw that in there. All right. So when you look at an equity framework, okay, and how, if you were managing a trust estate, okay, keeping in accounting, preserving the assets, whose interests are being protected here, who's the beneficiary, keeping a fiduciary discipline. In other words, doing what you're supposed to do in order to protect the beneficial interest of the beneficiary. It's not your stuff. Okay? Have remedies for any potential situation that comes, knocking on the door. Right? They always say in law, it's not a matter of if you're going to get into a lawsuit, it's just when. And they believe that because people love to argue. Anyway, procedural preservation. If you get into a legal conflict, you need to know the rules and having a system to keep that in order. Okay. Understanding their rules and keeping track of them, okay, does not mean you're tracking. That's like knowing the other side's rule to the game, okay, and knowing that you don't want to play that game. They want you to come in and argue. Okay? We preserve equity by stewarding that procedural rules, by knowing that what are the rules for filing a motion or for filing a notice or word counts and spacing and all the ridiculousness that form is. And the law is all about form, not substance. Okay, so procedural preservation. You control the procedure by knowing how to play the game, knowing the rules, and then recording everything. And from day one, you're preserving your equitable record, all record for sure, but the evidence of equity that you've been bringing from day one, that all adds up. And that preservation for appeal is part of the system that you would create to deal, if you were managing an estate, how to deal with these types of attacks on the estate. Okay. And again, it always comes back to long-term stewardship and conscience-based administration. You're trying to create a legacy, pass things down from generation to generation, and keep the state at bay, okay, and any outside third-party interlopers from trespassing or stealing things that belong to your not your trust, but the things that were entrusted to you. Okay, equity is conscience-based administration. Okay, that is what it is. And in the private, you can control that. If you look at the TV or into the public, into the purview of the public, where do you see conscience-based administration? Is there anything in there that's based on the conscience? I'll let you be the judge of that. All right. So equity ultimately asks, who remain faithful to stewardship, preservation of property and rights, fairness, accounting, and conscience, while controversy tests everything entrusted to you. Okay, because when you're in a battle, it tests out who you are. And you can whine and cry and throw fits and complain. The system loves complaints. Or you can do your job as a faithful steward to your trust estate, to your family and your heirs. Okay. And you can create a foundation of equity that can be evidenced ongoing when it's questioned. All right. So far, guys, all I've introduced, okay, in this seminar, foundations, frameworks, the mindset of equity, and some of the systems that are involved. Okay. There is a full course, and that course includes 100 lessons, templates, preservation systems, complete preservation systems, how to bring and defend equitably within their system, within the system, okay? How to get into equity, how to stay in equity, how to bring equity, how to point out when things are inequitable, and how to hold those that are inequitable accountable in real world, in real world situations, okay? It is fiduciary administration mastery. It's less about techniques and more about living in these principles. Okay. So how do you lose it? How does equity disappear? Okay. Well, nobody can account, right? There's a lack of liability. Nobody accounts for the things they've done, right? Everybody gets emotional because what's the best thing, what do most people do when they're attacked and they have no answer, right? They'll attack emotionally. It's an emotional reaction. It's not logically thought out or just doing your job. It becomes personal. And that happens all the time. So preservation, things are abandoned, right? So, you're abandoning ship and, whatever happens, happens, right? People's interests are ignored, record keeping, right? All these things, okay, are just warning signs, little red flags. If you're, hey, I don't care what happens to the property, then you've already lost. Okay. The whole reason if somebody would be in a foreclosure is something broke down at some point. And I get it. A lot of folks, have been misled in how to deal with these things. It's been a remedy nightmare out there. People trying to get remedy out of things that never included them. Okay, the opinions, the statutes, the codes, the constitutions. Okay. Anyway, moving on. So, the power of an accounting. Okay, what does an accounting reveal? Hidden fees, improper transfers, fiduciary imbalance, right? Oh, over limited liability. You, the beneficiary or the supposed beneficiary, you have the fiduciary duty. So how am I a beneficiary if I'm paying for it? There's unjust enrichment, whether there is unjust enrichment, and if there was any beneficial harm to the beneficiary, right? So before enforcement, the accounting has to be shown. And these are the things that you're looking for. Okay. So when you are working in being equitable, okay, and this is why it's not something you just keep in your back pocket. Okay. It's a way you're it's a way that you're administrating equitably. You administrate every day your estate, your affairs, the things that were entrusted to you, your children, your house, your job, your car, your business, whatever, right? And you need to keep organized records and accounting and transparent accounting. It's not for some interloper to come in and just, uh, uh, because they say so, have access to your transparent accounting. It's transparent because it's easier for you to manage when it is. It's your accounting. The accounting is for you. Okay. Beneficial protection. Are you doing your job as the fiduciary, as a trustee, protecting the interests of the person whose property it is that you are administrating? Are you willing to preserve their rights and the property? Right? Are you able to, do you have the tools, the equitable tools to use in a courtroom in case someone tries to bring you under a lawsuit? And your credibility, again, that's what's evidenced in your record keeping. Okay. It's there, it's yours to prove or fail to prove, depending on how well you keep them. It's one thing to have a shingle out in front of your business, but it's not a real business if there's no clients, no customers, no products, no inventory, no services. It's just a shingle. Okay. It's a shell. So don't let your leverage, your accounting and record keeping provide just a shell like so that you can say that you have authority over that property when you haven't managed it properly. Okay. Emotional escalation, procedural chaos, and poor accounting does not give you a stable standing, your position. Okay. And literally, if the other side wanted to, they could claim that you've been inequitable or in breach. Okay. But when you see these things here, again, you got to look at both sides. And again, I asked to look at this from the public side. Do they do these things? Are they doing what a good trustee should? If not, these are the chinks in their armor, the holes in their wall. Okay, and can be. So, what are the remedies in equity and when you're dealing with the courts? I'll say, okay. These are not all of them, but these are the most used. Okay, injunctions, accountings, constructive trusts, restitution, equitable redemption, declaratory relief, rescission, reformation, and equitable set-off. These are all tools that you can be using in a courtroom in any case that, where the law is failing, you can seek, or right up front, you can challenge the jurisdiction that it should be equity, that that the party in question is a trust. I'm not going to get deep into that, but I'll leave that there for you to chew on. So, a constructive trust. Okay, when equity imposes a fiduciary obligation, a trustee transfers trust assets into their personal account. Okay, that creates a constructive trust. Why? Why? Okay, when that happens, they basically, and it's not recorded properly. The appearance is that there is unjust enrichment. They took something that doesn't belong to them. Were the beneficiaries harmed? That's what equity is going to ask. If it's their property and the trustee absconded with, a couple grand, a couple thousand grand, a couple $100,000, they could, did they harm the beneficiaries? And if so, there's equitable remedy. Was it concealed in the accounting? Okay. So a constructive trust would be created in a court situation. And like I said, you're seeing a constructive trust in all of these administrative courts anyway, because they are administrating the legal person. But the constructive trust can be established by you, okay, and not by you, but by what went on, okay. It can be assumed or presumed that a trust is there. They borrowed the money and just didn't account for it right now, but they had every every intention of returning it, right? And that's how that would be expressed. That, okay, this is what they said, that it wasn't about unjust enrichment. They didn't mean to harm any beneficiaries, that it was temporary. You hadn't had a chance to fix the accounting and account for what actually happened, and you always intended to repay the trust and plus interest or whatever. Okay, but the trust is a duty. Okay, a duty is created by the actions itself. Okay, and that's a constructive trust. Equitable set-off. Okay, so an example would be one heir occupies estate property, a house owned in the estate, and one of the other heirs is paying taxes and maintaining that property, okay, at their own expense. Okay, so the example here, one is getting the benefit, the other has is paying their portion and the other heir's portion, right? So there's some subrogation rights. That's also another equitable remedy. Okay, we've talked about that last month. Anyway, we talk about that a lot more in our student calls and within the course materials. Okay, so equitable set-off would be balancing the occupancy and the preservation. It first off requires an accounting. Okay, how long? So from the time of death until the time that they stopped having the exclusive occupancy of the property, they owe the other heirs market rent minus those expenses, and now the accounting will be done. An equitable offset, the house is sold, and the portion that was due the heirs that were making the payments and maintaining the property would be reimbursed, and the portion of that was due by the occupying heir would come, and that accounting would be paid, bringing back equality between the heirs. Nobody's being unjustly enriched. Okay, and got a little bit more to go here on the presentation, and at the end, again, I'm sure that you guys will have some questions, and I'll open it up for questions and answers at the end of the presentation. So, undoing unfair agreements. Another way that equity can be used is to rescind contracts where fraud might exist, or there was no disclosure, or unconscionability, right? A fiduciary imbalance existed. So, this one got all the benefit from the thing, and this one's got all the liability. Okay. And the goal is in rescission to restore parties to their fair positions as if the interaction never took place in the first place. It's not about one person walking off with a windfall. So, what destroys equity? Now, if you're looking at equity in property as an example, right? You miss deadlines. If I didn't pay the rent this month, or the taxes, or the this, or the that, whatever. Okay. And by doing that, you're waiving rights. Right? You can't say that, no, I'm in good standing. Right? So you're waiving a lot of rights by missing deadlines. Pleadings, right? Filing pleadings with the courts, arguments, and emotional filings that get you nowhere. They make courts busy and lawyers rich. Okay? You don't have evidence. You don't account properly. You fail to preserve objections and equitable rights, and your evidence is disorganized. You're going to have a very hard time keeping your equity in your home. Okay? I'm just saying, to use equity in a home as the example, but the same goes in the court. Equity is equity. It's an ownership interest. Okay, it's what you own minus liability. It's what's left over after all liabilities are paid. Okay. All right. So when you set up systems to prevent inequitable situations in the first place, fights and lawsuits, things like that, things that are going to bring you into that legal side of the court. Okay, if you've got systems in place ahead of time, you have your accounting, everything has been consistent in your administration of your affairs over time. Bringing that in is simple. Put challenges that you haven't met. Okay. You have it all right there. You have the evidence ahead of time. You've got systems to monitor where there may be attack. Right? In the public, they're doing this all the time. Right? Foreign affairs. No, you're doing that from your private trust. And everything outside of it is private, is foreign. Communication. Calm, organized. Preservation of rights and properties. Right? A right is a property right. Transparent, easy to understand, and discipline. Communication. Don't lose your cool. You will give up leverage. Happens all the time. You acted inequitably. And if that's on the record with your communications, screaming and whatever, it's on the record. That's not an equitable thing. It's not clean hands. You have to clear the record. You have to wash your hands at that point, clear the record. Make up for the mistakes you made. fix your communication and apologize. So equity looks at conduct, stewardship, accounting, preservation, neutrality, and consistency. I'm talking about this on the private side as a trustee of an estate. In the public, are your public trustees conducting themselves well? Are they good stewards? Are they providing accounting to those beneficiaries that are beneficiaries of that system? Are they preserving your assets or harming them? Are they actually neutral? Or do they have an ulterior motive? And is it consistent over time, or is it chaotic all the time? The trustee becomes part of the evidence, guys. And again, I keep hinting at that. But again, when you're bringing equity, okay, this is the evaluation for the other side and you. Put them to the tests. Equity asks who benefits, who bears all the risks, who preserved the property, who requires protection, okay? And the one who gets protected is the beneficial interest holder, okay? It's the beneficial reality, the actual beneficiary, not just the appearance of taking care of them. And you see that in parents patriae cases all the time. Oh, it's for the child's benefit. Is it? Or is it for cash? Just throw that in there. Put them to the test. All right, so property is a lot more than just a title, okay? The trust could hold equitable and legal title, okay? But that doesn't necessarily show who all the all the beneficiaries are. May not show all of who owes fiduciary duties and how, who has obligations, who has duties to account, okay? These are all different interests. So it's more than just two in a split title, right? In a split title, there could be, I could have 15 beneficiaries on a piece of property, each with their own interest. And that could be in the private record, okay? But just the fact that the trust is holding equitable or a trust is holding beneficial interest for those 12 interested parties, okay, would confuse proper parties and interest among a lot of other things. So property involves more than just the title itself, okay? There's a lot more to the title, right? You could buy a property and get title that has covenants on it, right? Those are other contracts that you are, or may, depending on whether you accept those as part of the deal. Again, you're buying it. So, all right. When procedure accelerates faster than fairness, when the law oversteps its bounds, okay, equity can intervene, okay? So where there is no remedy in the law, equity intervenes, okay? If an accounting is incomplete, if beneficial interests other than the party in the case is endangered, but their interests are need to be protected, okay? If there's irreparable harm being threatened, and if preservation is ignored. If somebody who had a fiduciary duty to preserve the property didn't, then equity can be used to create an injunction and a court order to do the thing or to stop doing the thing that they're doing. Okay, injunctive stabilization. All right, so we look at this, and when you go into a case, that what happens if we don't win in the lower court? We may have to appeal it to the appellate court, and then even further, if need be, if your rights are continuously ignored, equity must move. It doesn't. Equity does not delight in halves, okay, or things undone that should have been done. Okay, so you may be appealing all the way through, You may, and you may not, but you always start and maintain equity from day one. Appeals are built from day one. Preserving objections, preserving rights, keeping your records organized, having an accounting history of whatever is going on, right? Timeline documentation, what happened, that's the story, and what evidence backs that story up, and preserving the remedies available that equity provides. All of that's got to be preserved from day one. So we've talked about this before. Systems prevent collapse. Okay. Counting systems, preservation tracking systems, beneficiary systems. All of these systems help you to see ahead of time, where there may be a danger of loss or waste or breach, total breach. Systems are built to protect those things. That's what the course teaches, is how to, how to build those systems and how to, practically use equity when dealing in your everyday administration, and absolutely when protecting or defending the estate from the oppressive system of law, right? Which is oppressive. It's the letter of the law. It is to keep the conscience alive in that courtroom all the way through. This is, again, equity survives through consistency, right? You drop the ball, you forfeit your rights, the equitable rights that you may or may not have had, you completely forfeit. If you don't keep it consistent, you will find yourself back in statutory subjection. The case will be. So your systems are going to, red flag threats, whether they're accounting, preservation, beneficial interests, fiduciary review, remedies, right? Gives you a way to keep an eye on these things in case your estate gets attacked or you get attacked, in the way of a lawsuit or a claim against you. Okay. The same thing is the same standard, okay, that the public in an equitable jurisdiction is held accountable to as well. Accounting. How about the case accounting, right? The administrative accounting for the specific case, the docket. Is it right? Did the clerks put it in there right? Were there mistakes made? There's lots of things that are again, you're seeing the whole story, but it applies on both sides of the court. Equity, when you bring it in, all parties are now held to the same standard. Okay, not just the statute or the formal law, but the substance underneath. And again, conscience-based administration, long-term stewardship is the goal, right? Not being trespassed upon or subjected to based on tort administration. All right, so the whole course, again, 100 lessons, the complete equity warfare systems for defense and offense, preservation systems. It's literally systems, okay, guys? This is not just this is not something that you just need to put on the shelf, okay? This is a way of organizing and making sure that when you have issues with the courts, that you're able to put together a system that you can build a defense or an offense or be able to prove or disprove claims, okay? It's being able to manage the information and be able to utilize it in a way that gets you the remedy that you're looking for. Okay. It's designed for people who are trustees, fiduciaries, beneficiaries that want to understand the rights that they have. The beneficiary in a trust is the one who is the true owner of the property in trust. Okay. So a beneficiary that doesn't know they're a beneficiary or what that means and what rights they have is, you know, basically a gift recipient without a clue that the gift is coming. And they may not or may not want the gift. And, just like found money harms a lot of folks, it may do it to them if it's not structured and they don't know ahead of time to make plans on protecting and defending their benefits, right? Their ownership of whatever it is, right? People who steward property, someone who's in foreclosure. The reason I did this, guys, was because a lot of people come to me with issues that they're dealing with right now. And when you start understanding equity and how you can utilize some very simple principles to defend these claims that are coming against you, and flip those tables over and into a different jurisdiction within the court structure itself, it can benefit you now. It doesn't take a lifetime of study. It takes putting the principles into practice. So you can go to the Bulletproof Solutions website. If you've liked this seminar, you can get over there and sign up. And I'm offering a 10-day free to anybody who wants to go in and look. You sign up for Exploring Foundations membership. It'll give you a 10 days free, and then it's $25 a month. Gives you access to a whole bunch of things like the free seminars and access to the course, the course catalogs and newsletters and different things, other live calls. Okay. If you see a benefit, come on and join the community. If you're interested in taking this course, you would go in and sign up to be a trustee and training membership. And then you would get 10% off the course with that membership. Okay. Tonight until the end of the month, I am offering a $500 discount off the price of the course. Okay, it's $3,000. I'm gonna knock off $500 for anybody who's on this call or hears this call prior to the end of the month. You can sign up and I will be posting a coupon for that $500 off in this call here at some point after the call. Okay. Preservation before destruction, accounting before enforcement, and stewardship before ego. Okay. Equity. Okay. This is the end of the presentation for the most part. Equity is not something that you just use. It's not something you just pull out of your pocket and think that, hey, I'm going to use this, this get out of jail free card today. Okay. It's a way of living. It's something that you don't need to look over your shoulder because you already have clean hands. Okay. It's not something that you pull out. It's something you do daily so that when an issue arises, you already know how to deal with it. And this provides you with a track to run on to be able to do that. All right, guys. So that's the end of the presentation. I will open it up to questions and comments. If anybody has questions that they'd like, now would be a good time to do that.
Hey, I just wanted to say thank you for this presentation. It was really well put together, and it sealed a couple holes for me in terms of how to express equity.
I'm glad. Thank you.
I'm trying to make my question very quick and succinct and as uncomplicated as possible. I know you have a lot of property examples, foreclosure examples, but what about something like a little slightly more simpler, such as like registration of a vehicle, right? And you're dealing with a franchise tax office that relies on another office to get the accounting and get the numbers and things like that. And it's not accurate. And so you're kind of bouncing between two offices where nobody's taking full accountability of what they're actually requesting. Or if they make any corrections to it, before you can settle it, certainly you would need to have like an updated communication. And do you have to keep forcing that communication between the parties?
So
Does that
is
make
there an
sense?
active case? Is there an active case already, or is this something that there's somebody's keeping an accounting from you that is required to actually get the full understanding of a case in order to bring it?
Yeah, no,
Is it
no,
information that you're trying to get, or is it something that's actually somebody filed a claim or you have filed a claim?
no claims filed and no cases at this juncture. It's a tax office that relies on the DMV for numbers, and the DMV is, I didn't even know they were involved the way that they are, but they have pretty exorbitant fees, right? Like, how did $109 turn into 800, And then when I
Sure.
asked the gentleman to break down the fees, they're paying three different government offices with the fees.
Okay. So when you get this information, you're only getting part of it because part of it is in one department and two other parts are
Mhm.
in two other departments.
Exactly.
So again, once you've recognized all the proper parties and interest, and you would do an administrative process, literally, in within your, what you're requesting, why, and why you have a right to the information. And your communications have to be equitable from get-go, just to put it into the vein of what we're talking about here, to preserve your equitable rights throughout. So if there is a case that does come up, something in that accounting is off, it can easily be challenged because you've got all the parties covered. So it is by an administrative process. We teach that all the time, and within the trust estate and dealing with administrative processes, which is administrative notice. We require this accounting, and this is why we're entitled to it. And you have a certain amount of time, a reasonable amount of time to provide the information. And if they come back and say, well, we only have part of the picture, we don't have the full picture, but this is where we can give you our part in that picture. You would have to go over here to these two and get their information. But we are, consider us that we've given you everything that we have, right? And pointed you in the proper direction. They did what was equitable, right? Now you've got to go and do the same thing at the second department and the third department. And at that point, if any of them fail to provide the information that you're equitably entitled to, okay, then you would have a claim. Until then, you're only trying to get the accounting so that you're able to understand your rights and potential remedies. Does that make sense?
Yeah, it does. It does. I guess what's annoying for all of us is that they put us through so many hoops and loops, and you know the mailings and the notices. I mean, it's like, oh my God. The stamps, the paper, the time, the energy is
That's
incredible.
all
And then,
procedure, though.
hmm,
That's all the procedure, and that's where in the law
yeah.
it's very tedious. It can be exact. It is exacting, and it's hard to manage that. And again, that's why I set up systems to manage in case management. It would be the same thing, and equitable managing your equitable rights. It's the same as managing your case grounds, right? The reasons
Hmm.
why you have a case or defending a case in the first place.
Mhm.
So it's being able to administrate that, manage it, keep tabs on deadlines and dates, and because again, if you're trying to make an equitable argument and you sleep on your rights, then Latches would say that you slept on your rights. You didn't do things in a timely manner. That you lost track of the procedural calendar. You know, and that's another way they'll bring it back into law. So yeah, it's simple, but it takes I think the easiest way to do it would be with systems, recording
Yeah.
and documenting your evidence all the way across the board. You're just making it easier to present it down the road. So
Mhm.
hopefully that helps. Thanks for your
No, it
question.
did. It did. I guess, because they're getting their information from the DMV, and I think the DMV is a department that is in trouble under the Republic, right? Because the fact that they have even that registration date that they have on there next to our pretty picture. And that and the business name, like that document alone is fraudulent all by itself.
And again, that is an argument that could be made. It doesn't necessarily have to be made um, by you. The better leveraged position would be from within side of a private trust, you know, because again, when you're looking at the legal person that you're administrating, if you're administrating the legal person, that's what gets us caught up as a surety for the legal person in the first place within their,
That's true.
within the public side of the system. It's
Hmm.
because we're trying to administrate the affairs, and we're supposed to just enjoy the benefits. If we're a beneficiary, we'd act different.
That's right. That's right.
We'd act differently. We wouldn't be worried about covering the bills. It's not our duty.
Hmm.
We'd be enjoying the benefits or saying we're not interested in the benefits. I pass. But we're acting like fiduciaries. So they treat us like fiduciaries and they will say, okay, great. You're going to pay the fine and the fee.
Right.
But it's our own fault because we don't know who we are or what position we're in and what hat we're supposed to wear, what capacity we're acting in. And I've been doing this for 39 years, and it's not an easy thing to do when been doing it your whole life. I can't even imagine, going back to the beginning and starting from scratch because there's so much to know in their system. You've got to know the opinions of this one and everybody else for the past however many hundreds of years that they've been, making their opinions law. And it's not designed to give you a way out. It's designed to keep confusion and form and deny conscience altogether, because then you can do away with liability. So the system was designed that way, and they're not going to change it for any of us. That's the same as they're not going to provide you with equity. They're not going to give it to you when you show up there. You have to bring it with you.
Hmm.
If you want peace, you got to bring the treaty.
Yep.
And it's got
Well
to be
said.
fair for everybody. It can't be unconscionable. It can't be one-sided. Then it's not equitable. It'll get rejected. Somebody will reject it or find grounds to reject it.
Well, when you're
Good.
registering a vehicle, aren't you in a, in fact, well, unless you're controlling it through your trust, aren't you in fact making them a trustee that should be putting gas in the car and repairing the car and all that good stuff? They're
Oh,
asking for a registration of
you're
this property
creating
in
a
that name.
trust. I would say
Mhm.
yes, if their indenture didn't point to the, they change those things to transfer liability to the user, not to the
Mm.
owner. Okay, not to the fiduciary. They're the public trustee. Okay, and
Mhm.
the trustee has a fiduciary and legal responsibility to take care of the asset, to maintain the asset, all those things you just said, right? But
Mhm.
when you go and you created a trust with them, you registered the vehicle, that split the title, you became the user or slash beneficial interest holder slash equitable title holder. Okay, they retain legal title. They're the trustee. They're the ones that can call you out for breach of trust and all the things and it all is in within their rules. You entered their trust. The rules of their trust are that the registered user has to have license, permission from the legal title holder to utilize the property. If they don't, they can be fined. If they utilize the trust property 5 miles an hour over the speed limit that's posted in any location, then they breach the trust and they owe a fine. They transferred liability and suretyship to you. Actually, you did it yourself when you signed up for a trust, or for them to be entrusted with the property. You basically signed up, volunteered to fall under those rules. Okay, so when you move it out of there into your own private trust, the property is no longer in their trust. They no longer retain legal title to it. If you set
Mhm.
up a new trust in the private and you register it into that trust, there's different rules. There's a different indenture. There's a whole
Mhm.
different bunch of rules on how the property can be used, who needs permission, who doesn't need permission to use it, and reporting requirements and everything else are internal. It doesn't have anything to do with the DMV. So if you put your property into private trust and then go in and register that private trust property into the public DMV, you just created a new trust and collapsed your own trust. Because
Oh yeah,
when you
that was
register and create a new trust, you are literally saying, I don't trust you with the legal title, so I'm going to entrust it to them. And people fall back into their own, you know, lack of understanding and fall back under the law and under the law that they just fought to get out of by collapsing the trust and putting it into into under new owner, or excuse me, under new management in the private. And the public makes it very easy for you to come on back in. Believe me,
yeah.
they'll use
Well, I'm not
language
even in
that
that
you.
state anymore. That's the kicker. But no, I understand everything you're saying. I do. I really do. It's just that they just popped up out of nowhere, like 3 years, literally 3 years later. Like, hey,
Well, that's
we have
because the
some
statute of
money coming.
limitations is running out. That's why. 3 years, the
Okay.
statute of limitations under the statutes are running out, and that's why usually if there's a debt owed or something like that, they have to make their claim before the statute runs out, and usually they'll wait till the last minute to keep that alive, so that it shows that they're not sleeping on their rights.
Uh-huh. Okay. Okay.
Great question, so thank you.
I
Any other
appreciate you. Thank
questions?
you.
Yeah, you're welcome. You're welcome. I hope that helped. Any other questions that anybody else? The mics are all open. Nobody's muted. So if you have a question, now's a good time.
Hello, David.
Hello. How's it
Yeah,
going?
well, it's still going. Missed part of the meeting there, got home from work late as usual, but this is an interesting conversation and really ties into my situation here in beautiful British Columbia, where it's the first part of Canada where they're applying these UNDRIP declarations, the UN Declaration of the Rights of Indigenous Peoples, to claim the property back. And there's some more pressing news coming out about this all the time. So there's already been a couple of cases where public property has deeded property has been given back to a indigenous band. And so this is my priority is to understand how to best protect myself, if possible, with these upcoming changes. So one thing you just pointed out tonight, you gave an example that perhaps you could purchase a property that has a covenant or a number of covenants already attached to it. Would you give me an example of what that might look like?
Oh, we do it all the time when your property. So like where I'm at in the city here, there are, the property line goes out almost 20 feet beyond my fence line. And the state, the city, have contractual variances on the property. Okay. The electric company that's hooked up to this house has a covenant on, on the deed that allows them to come and check their equipment on the property, the meter, to be able to take readings and, fix certain things that they are contractually bound to that contract to keep right. Okay. Those are covenants. And again, the deeded, the deeded title to the property, you can look at, it's just like the deeded property to your vehicle, right? If it is a deed issued by the state, then it's entrusted to the state. They're holding legal title, and your deed, your title, is a user title, right? Tenant in common. Right. I mean, I'm not making this up. You can go look at your deed. Everybody, you can look at their deed and see that you're a tenant. You're not an owner. You are, and whoever issued it is the legal title holder. You're an equitable title holder, which means you have equitable benefits and can do something. You have remedies. But these are contracts, these are covenants, and you never see that. You have to expressly rescind, right? Rescission is another equitable tool, and you need to rescind those covenants and can prior to or after the fact, if new information comes to light and it requires administrative changes, then those covenants can be rescinded, each and every one. Now, again, if the contract's no good, then the benefits that came along with that contract are no longer valid as well. You have to manage those things that you are, those things, those services that you're paying for in those contracts are now, a state responsibility. Putting fires out or dealing with trespassers or whatever. That makes sense, Walter?
Yeah, that's making sense. I'm not. I should spend some time on this and really prepare a good set of questions, because I think this is a very unique situation that we're in with these court orders, and that they just push it through with no public hearings. There's no public notice. It's just a big strong arm tactic. So I'm trying to get my head around the possibilities of how I can be ready to defend myself in this situation.
Make sure that your evidences and your chain of ownership is very well documented. Because if they're going to come in and try and it would be the same thing as what is it called, where the state comes in and basically takes your property. Looking for the word. Sorry, guys. You might have to.
Like an annexation?
Well, it is, but it's something very specific in the law that says that they can come in and take it, but they have to compensate you with the current market value plus any inconvenience, right? But it has to be for a benefit of the public, and I cannot, for the life of me. Boy, my mind's got a little hole where that term is.
Yeah, well, no problem. And I think I know what you mean there. This may not really apply to this situation because what they've done is they've handed over the jurisdiction to a minority group of people. So
Okay.
I'm not sure how this is going to play out yet. So I might be under a new so-called jurisdiction, and I'm not sure how I would try and approach that, as I've been learning how to do it with what the situation has been up till now.
So is this now moving from, let's say, a Canadian federal jurisdiction to an indigenous jurisdiction?
Correct. That's the way it appears. Yep.
And how are they protecting rights of those who own property that's been, there's got to be some way to grandfather that in for protection. And if they're annexing it back into indigenous territory, it would have to be, I would assume, and again, I'm not, this is my own assumption, that that those who are affected legitimately have a claim should be compensated equitably. So this is a perfect spot for equity to make sure there's no unjust enrichment.
Right. Yeah, I need to learn a lot more about this and have some more specific and pointed questions. But thanks a lot for now, and I'll get to work on this and hopefully chat with you later.
All right, good questions, though. Thank you, Walter. Any other questions? Comments? Anything you guys need explained a little bit further? As far as moving things into equity, a lot of the time, again, having the principles and understanding these principles, if you're utilizing them in your daily administration of your life, okay, it's not going to be something that you're out of practice with when something comes up. How many of you are fighting things that you weren't prepared to fight in the first place? That you're playing catch up to try and even figure out the rules or how the game is played or where why are you getting railroaded and how do I use these codes and statutes and case law to get a remedy, to get equity. The equity's not in those things, guys. But equity is what everybody's expecting. It to be fair, it to be the right thing because it's the right thing to do. True justice. The law doesn't provide true justice, only the form of justice. It's not substantive justice, guys. And that makes a huge difference in the game. It flips the table on the game that they're playing. They want to play form law, fictions, assumptions and presumptions. Equity's facts. It's very fact-based. So keeping a good record, like we spoke about throughout the presentation, is the first step in being able to overcome and move something where the law can't reach. It's ineffective. And when it's ineffective, equity jumps right in. But again, it's not going to just jump in. You've got to bring it. You would expect it to because that would be the right thing to do. But they know that they don't have to provide equity because or bring you an equitable solution. They're going to tell you, well, we can't counsel you on any legal matters, right? They sure are not going to counsel you to force them to be fair, to bring a conscience into that very legalistic, rigid system that they enjoy doing because it's profitable. There's a lot of unjust enrichment, and they benefit from it. So again, they're not going to provide it for you. You have to bring it yourself. And guys, I'm not giving you a remedy that is burdensome to learn. There's very few principles that you would have to go and learn and put into practice to be ready for any situation that could end up, that should be equitable but ends up in a legal venue. And you're going to have to be the one that brings it back into equity and keeps it there until there's a final solution to the question at law. Anyway, any other questions, guys, before we wrap it up?
Yes. Can you do a review of the price, the discount? Is there a monthly payment option, etc.?
Yes, there is. There is a monthly, and I'm doing that for all the courses. You can do, it's further discounted for single payments, but every single course at this point should have monthly payment options. So yes, Tom, I'm working on that. We've done done a ton of work on the website. If you're finding that isn't the case, please let me know, and I'll make sure that I can get you what you need for a payment agreement on on any of the courses that are out there. I get it, and not trying to make this hard for people to get a hold of the information. So I definitely, and I've always put payment options out there as well. So yes, Tom, thank you for bringing that up. Oh, and by the way, Tom, I don't know if you noticed, but I did add a reader to the site. I'm working all the bugs, but that you should be able to use in any of the courses or any of the pages on the site to be able to have it read to you rather than having to read it. I know a lot of folks learn better audibly than they do through visual. So I thank you, Tom, for suggesting it, and I'm working on putting it in place. You should already see it there in the bottom of the website on every screen. So
I should be able to go to the course that I was taking and try it out.
Yep, it should read it out to you if that's what you'd like. Yep.
Okay, we'll try it and let you know.
Thank you. Well, thank you. I'm still working out the bugs, but it's there and it should work. If it doesn't, let me know.
It's in English, not Chinese, right?
Oh, I believe that the thing can read it in 168 different languages. So whatever you choose. Any other questions, comments? Anything that needs further explanation? Go ahead, Chris.
Hey, Dave. Just a kind of a specific case. Say a repossession 5 years ago. And I'm taking this exclusive equity. It applies universally, like worldwide.
Yeah, and especially if you're in a crown country, for sure.
Yeah.
Yep.
Yeah.
Yeah, you still have the King's Chancellor and all that. I believe it's King's or Queen's Bench or whatever. I'm not up there, but I would, either in Canada or Australia or England or any other, country that has got common law and civil law, equity is there as the conscience of the law. So yes.
Yep. Cool. So just with that, the maximum of equity involving sleeping on your rights.
Latches.
So going back in time 5-6 years, does that apply, or is it because now that I've basically learning about the rights and about equity?
Well, and again, that's where the argument can be made. Is it? I mean, if you knew that your rights were violated back then, you'd have done something, right?
Yep.
So you can't go based upon when you could have known. You have, and if you bring the claim, you're going to have to overcome why it wasn't done in the last 5 or 6 years to overcome latches, because latches is an equitable defense to a claim. And if they say, hey, you know what, you slept on this for 5 years and they're going to, right?
Yep.
They're going to come in and say, no. Look, you're trying to bring equity, but you've slept on your rights.
Yep.
For the last 5 years, you disappeared with nobody heard anything. It's long past the statute of limitations, right? And then they're going to try and move you back to the statutes and the codes.
Yep.
You're going to have to bring the grounds as to why. Why did it take you 5 years to come back and try to exercise your rights?
Mm-hmm.
So again, the rules apply to all sides. You can't expect the other side to be equitable when you come in with clean hands. So you have to, again, you're going to latches is going to have to be overcome in any claim that you would bring at this point. That's something that you'll have to address. And this is where a remedy matrix comes in. What can I stand? What am I going to have to deal with? But you're dealing with, 26, 27, whatever, under 30 maxims and different types of remedies, not millions of codes and statutes and all this other junk. So the learning curve is much smaller, and your remedy pool is pretty exacting. There is a remedy for each issue, and you just have to express the remedy, express the solution, bring it with you. And part of that solution in your case, if it's 5 or 6 years, is going to be overcoming why you waited so long. They will bring up latches, guaranteed.
Yep.
So that would just, that should tell you that, that's something that you're going to have to overcome in bringing your claim ahead of time. Don't just bring it and then expect to have, they're going to answer and say, well, no, this should have been slept on. This happened 6 years ago. Mm-hmm. Why is it 6 years now that all of a sudden it's coming back? It shouldn't be allowed, is what their argument's going to be. So you better come with an answer and a solution for all of it up front if you're going to be heard at all. It could be just, and again, the judges and stuff don't always have to, they'll say they don't have to do what you say, okay? But if it was the solution and they kept the solution from happening, they can be held accountable.
Right. Okay.
And again, the best way to win is know the rules better than they do, guys.
Yep.
Know them better than they do. Rules of procedure, that's the law side. Should you know it? If you've got deadlines and court dates and pleadings that you got to file, I'd say it'd be a good idea to know it. And knowing how to overcome those things with equity to bring you into equity and basically say that the law is insufficient to handle this issue. It doesn't fit into their form. This requires a substance view, a conscience view of the evidence. Anyway, I hope I answered your question, Chris.
Yeah, definitely. So it's basically be prepared, have a plan from the very start, and be prepared for it. And of course, before going forward, you would have set up trusts and private trust and becoming added from a trustee perspective instead of. Yeah,
I would say having a trust structure set up ahead of time is give you way more protection, way more leverage, and the proper authority to administrate. So you're overcoming a lot of stumbling blocks for a pro se. I'm representing myself. How do you do that? I can't represent myself. I am myself. Mm-hmm. Okay, and in equity, it's easy to do that. In the law, you're actually representing a fiction of law, the legal person. So getting that separation ahead of time overcomes a lot of the red flags and stumbling blocks that you would come up with in an argument otherwise. So can it be done? Can you use equity as an individual? 100%, and you should be. But again, there are easier ways to administrate your affairs from a much stronger foundation and security than flying out there on your own representing your legal fiction.
Yeah, of course. No, that's great. No, thank you, Dave.
You're welcome. Good questions. Thank you. Any other questions, comments?
I got one, Dave. It's sort of piggybacking on what others have talked about.
Yeah,
Mortgage
absolutely.
redemption seems to be a hot topic. Would a good tactic be to go for the accounting? And what exactly are we asking for in an accounting? I assume that we would fashion an equitable bill for an accounting to present, because it's really the accounting that's going to show where any advantage was taken. The books don't lie, but they hold all the cards until they give up that accounting. So how do you pry that accounting out of them, other than just saying a bill in equity for an accounting? How do you make them do it?
I'm doing it through right now. I'm doing that exact thing in the probate case with a declaratory action. A declaratory action in the states falls under the Administrative Procedures Act. Okay, you know that these courts are administrative and not not judicial. Okay, so there is something being administrated, and you know what it is, right? The legal person is being administrated. So when you are looking for that accounting, okay, it's the same thing. You would bring doing it in a declaratory action is saying, hey, this has gone on, that has gone on, these things have gone on. They're saying this, but there's been no accounting to prove it. They say that they certify, right? That means that they swear under penalty of perjury that the true accounting exists and all the original paperwork exists. And to tell you the truth, you should just believe them. And that's what they will, that they will say, well, we've already gotten certification that it exists. But if I'm the one that has to defend the position, I have a right. Right, which therefore I have an equitable claim. Okay? And rights are determined through declaratory actions. They bypass the entire docket and go to the front of the docket, because if those questions are answered, the idea was that it would save the judicial economy of the courts from having multiple lawsuits over the same subject matter. So I would use personally, a lot of the times, a declaratory action is the proper vehicle for getting that done, getting that accounting. Because it is a right.
What type of accounting are you looking for? Are you looking for a GAAP accounting, GAAP?
That's just the beginning of it.
FSR 9 or whatever? I mean, what is it exactly? Like you said, learn it well enough to be able to defend it. But
yes,
if we've been foreclosed on, or we have paid off a mortgage even and are trying to redeem it, we don't know.
Well, I mean, then if let's say the property was sold, then an accounting had to be done. Was it sold for a windfall? To somebody get a windfall? And where did all the equity go in the property? Because that's what you're entitled to redeem, is the equity, the overage of what was owed. That would be fair, rather than for you to forfeit it to the company who just literally stole your property and your equity, right? What rights do you have?
If they have the property now, they are a mortgagee in possession. So they've been made whole. So now you get to redeem for the all the collateral that you transferred.
Not just the collateral, but whatever equity was in the property to begin with at the time of the foreclosure and sale, right?
Yes. So, well, and the note, promissory note was one of them that we
The
never.
original note, those are all part of the administrative accounting, okay? So these things, all the pieces to the puzzle, it's not just the numbers, it's the administrative records that explain it all. It's not just the numbered accounting. So it's not just that gap accounting, it is the administrative record as well. Because without that, the numbers don't make any sense. So if you look at the numbers as the accounting minus the administrative record, you're missing the answer key to all those numbers. And it has to be a forensic accounting, complete accounting. Nothing can be missing. If they show up in accounting and there's 6 months missing, or if there's a promissory note that was not, you're not seeing the monetization and securitization of the original note accounting, then there's something missing. And again, you're entitled. So you could say, well, yeah, we got part of the accounting, but where's this? Oh, well, how did you know that this existed in the first place? Would be most of their answer. But you've got to...
This sounds like a case where if you go to court to try to force this issue and they come back with they don't want to offer it up, there isn't, I'd like to make this order and it all comes in. We have to know what we're looking for to be able to piece it all together. Is that what I'm hearing?
I agree. And a full forensic accounting means all of it. Everything that happened from the day that note was signed, the day that the mortgage was signed, any security agreements, that entire closing, all the tax stamps and documentations, all of it, every bit of it. Who got what, where did it go, and why?
And this is also, from what I can understand, something we would have either the judge or an officer sign to say that it's true and accurate?
Oh, well, in accounting, I know here in the States that certified public accountants can certify an accounting. And then they are held accountable against their certification to its facts. So, yes, a certified forensic accountant. Third party would be better because you don't want, you know what I mean? If you can, if a third party is required by the court, they can appoint a third party to go over their books. Okay, that's if it got to that. But you can request that they provide the forensic accounting, all of it, not just parts. If it shows up in parts and parts are missing, then you can go and say, hey, this was done in bad faith. This is only a small picture of what's actually there, and we believe there's more info. And you can force the court to do an injunction to produce it or to allow forensic examination. That help?
Yeah, it does. It's caused some more questions, but that's good because I didn't know what to ask.
Yeah, I mean, the forensic accounting includes the administrative record, the how, what, why, where, and when, right? And the accounting of the numbers is, book entries. The administrative record explains those book entries in very, very clear detail. On this date, this note went to the Fed window and was monetized and securitized. Right? On this date, they signed the promissory note and paid the security off. That's that second bookkeeping that everybody's trying to get to. It happened. You know that when a mortgage is created, that is sold at the Fed window and monetized, and then securitized and fractionalized. We know this, but that's all part of the forensic accounting. What happened to what, when, where, and how? If you have all the documents, then you need to show that you're still holder in due course of the note. Or did the note go to the Fed window and is now in MERS? digitally. There are no hard records, right? They've been destroyed, and we just accept that for what it is. And that's not necessarily the case when it comes to an accounting. Something happened. All of that, even transfers, appointments of rights to collect, all kinds of things are transferred all the time. The administrative accounting is what shows all of that. It's the actual record, not just the number record. Hopefully that helps.
Yeah. Okay. Thanks.
Yep, you're welcome. Any other questions, guys?
I added 2 references regarding forensic accounting, but I don't want to step on your toes. And if that's not appropriate, let me know.
Bring it up. I'm good with that. If you've got something to help, I'm willing to listen and answer. Go ahead. What do you got?
No, while you guys were talking, I was like, "Oh, okay. Let me see what I can find real quick." So I just posted two references in the chat.
Any chance they're Canadian?
I'm hoping it's basic principles that would apply across the board.
Okay, I'll have a look later. I'm on my phone right now. Thanks.
Okay, no worries.
Yeah, I would say that if it's the U.S., if it is U.S. based, that there's an equivalent wherever you find yourself. You just may have to search around a little bit, but the principles are exactly the same. Exactly the same. Because again, they're equitable principles. Accounting is an equitable principle, right? It's being accountable for your actions while you were entrusted with something. That's what it's all about. And the financial record itself doesn't show that. The administrative record does. Years ago, I was a private investigator, a company I worked with and for. We used to do audits. They would call our company. We had a forensic investigator, financial forensic investigator that worked for the company. We'd go in and find theft and fraud within banking institutions. So that forensic accounting would go in and look at the books, okay, and not just the accounting records, the GAT book entries, but the full administrative accounting that is the key, right? The explanation for all those numbers. And that you can trace to things went over here, things went over there. This person is the one that authorized it. Oh, look, we found a hole. And this is where they've been siphoning funds. Okay? And this is where the accounting, the public accounting for these things that you're trying to accomplish and find out so that you can see whether or not, there was foul play, requires these things. So you can imagine how hard they fight not to have to bring a true accounting. And in statutory, an assumption that accounting exists is fine under the form, but equity won't allow form. You need to see the actual accounting. I'd love to take your word for it that everything is copacetic and that these vaccines are safe and effective, but show me the proof. Show me the evidence. Show me the records. Show me all your testing. Show me every, dissenting doctor's opinion on your vaccine. You see what I mean? There's a huge difference between taking their word for it in form and getting a substantial, legitimate forensic accounting in equity. An accusation or assumption or presumption that it exists is all that's needed in the law side of the court. And this is where it's ineffective. That's one place where it's ineffective as a governing jurisdiction, a governing authority over the matter. And that's where one place you can move it to equity. Hopefully that helps and answers that question, guys. And thank you for sharing those. I think they'll be helpful for helping the people understand what a true forensic accounting means and what that means in an investigations from an investigation standpoint. We're not just investigating your books; we're investigating the entire record. We don't want the code; we want the answer to the code as well, because the books are coded, and the code key is the administrative accounting that explains it all. Any other questions? All right. Well, going once. If you've got one, feel free to jump in. Otherwise, I'm going to wrap it up, and I will post the recording here. I am going to create a $500 off coupon. If you're already a student and you've already got that other option available until I believe tomorrow, and after that, this coupon will be good. The coupon will be good after I post it, but you guys have a different coupon. But they won't work together. So either way, just to let you know. But anybody who's on this call or is interested in this course, I will post a $500 off coupon, and you will get an extra 10% off of the full amount if you signed up for the trustee and training membership as well. It is required for any of the students because there's a lot of other benefits there that, conference calls and live sessions and support. So anyway, that's my last plug for the course, and I will put it out there one more time. If anybody has another question that they would like to ask, now's a good time to do so. All right. Well, thank you guys for being on the call and your questions and participation. If you're new to this information and you just want to go and check out what we have to offer as far as courses go and the kind of training that we provide, then go to the website, bulletproofsolutions.org, sign up for the Exploring Foundations membership. It's free for 10 days, and then it's $25 a month. You get a lot of resources for that $25 if you want to stick around and do some DIY learning. I've got a huge library, tons of recordings and other materials that are part of that $25 a month membership. So feel free to come by and take a peek. It doesn't cost you anything up front. And you can go and take a peek at all of the other seminars that have been done. I was going to do one this month on debt, credit, and dealing with credit repair and things like that. But I thought this was much more important to get out there because, like I said, a lot of folks are coming to me with current legal issues and are looking for answers right away. This is something that can provide you remedy regardless of whether or not you're in an estate. Equity is there for you to use. It is the proper tool to deal with facts and evidence and to get remedy in. So that's why I did this one instead of the credit one. I'm going to probably post up that I think it was debt, credit, and negotiable instruments. That'll be next month's seminar on this call. In this group here, I'll be doing that seminar next month. Toward the end of the month, I haven't figured out a date, but I'll put it out there so you guys can take part in that as well. But feel free to come to the website and look around. Hopefully there's something there of value and that you can learn from it. On that note, guys, I thank you, and I'm going to wrap up the recording now.